Hello everyone. The topic today we will cover is rights and duties of buyer. Rights and duties of buyer, which is coming under Unit 3C of our subject Special Contracts. So let us discuss about rights of a buyer first. Rights of a buyer. So the first point is the buyer is entitled to have delivery of goods according to the terms of the contract. Further, the delivery must be made of the exact quantity purchased. So, to have delivery of the goods as per the contract, this is getting covered under section 31 and section 32 of the Sale of Goods Act 1930. Okay. So, to simplify this, let me cite one example here. So, let's say, suppose A is the seller and B is the buyer. A is the seller and B is the buyer, and B wanted to buy, let's say, good quality rice from A. Suppose there was a contract of sale between A and B, and A was supposed to supply B, let's say, finest quality rice to be the buyer as per the terms of the condition between them, that is between A and B. Suppose B wanted 10 kg rice from A the seller. Here B the buyer is entitled to have delivery of goods according to the terms of the contract. And what are the terms of the contract here as far as this particular example is concerned? First point, the quality of the rice, it should be finest in quality. The second point, the quantity of the rice should be 10 kg. So let's say if suppose A does not follow, A the seller does not follow these conditions which were earlier fixed both by A the seller and B the buyer, then B the buyer may either repudiate, that is to cancel, either cancel the contract or may claim for compensation. Okay, either repudiate or cancel the contract, or B the buyer may claim for compensation. Okay, now let us discuss about rights of the buyer. The second point, rights of the buyer regarding quantity subject to any usage of trade or agreement to the contrary are as follows. Okay, are as follows. So there are 2 points here, A and B. A, where the seller delivers to the buyer a quantity of goods less than he contracted to sell, the buyer may reject them. If the buyer accepts the goods so delivered, he shall pay for them at the contract price. So this is point A. Let me make it simple here. Okay, let me make it simple. Now this particular point, that is rights of the buyer regarding quantity subject to any usage of trade or agreement to the contrary, this particular point is getting covered under section 37 of the Sale of Goods Act 1930, which is talking about delivery of wrong quantity. Section 37, it is talking about delivery of wrong quantity. Now let us discuss about this first point here, A. Okay, suppose the seller and A the seller and B the buyer, let's say they made a contract of sale. Suppose A the seller, he was supposed to give B the buyer, let's say 10 kg of rice, but A the seller delivered to B the buyer only 8 kg of rice. So here the contract of sale was formed between A the seller and B the buyer based upon 10 kg rice quantity. But A the seller delivered only 8 kg of rice, that is which is the quantity of the rice that he delivered, 8 kg. Here the buyer B may reject the whole of the good, or suppose let's say B the buyer accepted the quantity of rice, that is 8 kg quantity, the buyer accepted. Then after acceptance, what will happen? B the buyer cannot reject the goods, and B the buyer will have to pay as per the price which was fixed during the contract. Okay, during the formation of the contract. Now let's come to point B, where the seller delivers to the buyer a quantity of goods larger than he contracted to sell. The buyer may accept the goods included in the contract and reject the rest, or he may reject the whole. If the buyer accepts the whole of the goods so delivered, he shall pay for them at the contracted rate. Okay. To simplify this, let me cite one example. Okay. Suppose A, the seller, was supposed to deliver B, the buyer, let's say 10 kg of rice. But due to miscommunication, A, the seller delivered 12 kg of rice. That is 12 kg rice quantity. Here B, the buyer, can either accept 10 kg of rice by rejecting the rest 2 kg of rice, or B can do what? B can reject the whole quantity of rice. But suppose, let's say, B accepts the whole amount of rice, that is 12 kg of rice. Then the buyer is having what? The buyer is having the right to pay the price for the whole quantity of rice. And as per the price which was fixed during the time of the contract. Okay. But suppose, let's say, B accepts the whole amount of rice, that is 12 kg of rice. Then what will happen? The buyer is having the right to pay the price for the whole quantity of rice as per the price which was fixed during the time of the contract. Okay. Now let us come to the third point here. The third point, it is talking about right of the buyer. Right of the buyer in case of delivery of goods of wrong description. So right of the buyer in case of delivery of goods of wrong description, it is getting covered under section 37 subsection 3 of the Sale of Goods Act 1930. I am repeating this again. It is getting covered under section 37 subsection 3 of the Sale of Goods of Act 1930. So, right of the buyer in case of delivery of goods of wrong description, subject to the trade usages or an agreement to the contrary, where the seller delivers to the buyer the goods he contracted to sell mixed with goods of a different description not included in the contract, the buyer may accept the goods which are in accordance with the contract and reject the rest, or may reject the whole. So to make it simple, right of the buyer in case of delivery of goods of wrong description. Let's say, suppose A, the seller, he was supposed to deliver to B, the buyer, let's say 2 kg of rice, 3 kg of wheat, and 2 bottles of, let's say, fruit juice. But A, without giving 3 kg of wheat, delivered, let's say, 3 kg of pulses. So B, he did not need pulses. Okay. So here, what B, the buyer, can do? What B, the buyer, can do here? Okay. So he wanted what? B wanted 3 kg of wheat. B wanted 3 kg of wheat. A, the seller, without giving 3 kg of wheat, delivered 3 kg of pulses to B, the buyer. So here, what B, the buyer, can do? The buyer may either accept all the goods. Okay, the buyer may either accept all the goods which were mentioned in the contract. That is, in this example, the buyer B can accept 2 kg rice and 2 bottles of fruit juice. Okay, not accepting 3 kg of pulses, or B, the buyer, may reject all the delivered goods. I am repeating the example again here. Okay, we are discussing about right of the buyer in case of delivery of goods of wrong description. Suppose A, the seller, he was supposed to deliver to B, the buyer, 2 kg of rice, 3 kg of wheat, and 2 bottles of fruit juice. But A, without giving 3 kg of wheat, delivered 3 kg of pulses. Okay, so here what B can do, what B the buyer can do, the buyer may either accept all the goods which were mentioned in the contract. That is, in this example, the buyer B can accept 2 kg rice and 2 bottles of fruit juice, not accepting 3 kg of pulses. Or the buyer or B, the buyer may reject all the delivered goods. Okay, so this is what the third point is all about, that is right of the buyer in case of delivery of goods of wrong description, so which is getting covered under section 37 subsection 3 of the Sale of Goods Act 1930. Now the next point is installment deliveries. Installment deliveries. So the buyer is entitled to claim delivery of the whole goods and is not bound to accept delivery of the goods in installments unless otherwise agreed. So in the case of a contract for the sale of goods to be delivered by stated installments which are to be separately paid for when the seller makes no delivery in respect of one or more installments, or the buyer neglects or refuses to take delivery of or pay for one or more installments, it is a question in each case, depending on the terms of the contract and the circumstances of the case, whether the breach of contract is repudiation of the whole contract or whether it is a severable breach giving rise to a claim for compensation but not a right to treat the whole contract as repudiated. Now, to make it simple, point 4, installment deliveries. Let's say suppose A the seller is supposed to deliver B the buyer 20 kg of apples, and B wanted the whole quantity of the apples in a single transaction without going for installments. Suppose A told B within 1 week A will deliver to B 10 kg of apples, and after 2 weeks more 10 kg apples will be delivered to B. Now here B can claim delivery of the whole amount, that is 20 kg apples together without going for installments if B agrees to it. But if B the buyer agrees to it regarding the installment delivery, then what will happen? Then the whole contract will go as per the terms and conditions set by both the parties, that is A the seller and B the buyer. Now in the next part we will discuss about another example. Okay, another example, another perspective. So suppose A did not deliver further apples as per the installment contract. Suppose A did not deliver further apples as per the installment contract. Let's say A delivered 10 kg of apples in the first week, but after 2 weeks he did not deliver more 10 kg apples which A was supposed to deliver to be the buyer. So during the first installment period 10 kg apples were delivered, but when it came to the second installment period, the seller A did not deliver more 10 kg apples. The seller A did not deliver more 10 kg apples. Here the buyer B, what B the buyer can do here? Okay, what B the buyer can do here? This is the question, vital question here. So this situation is completely dependent upon the circumstances and various situations, and it will always differ from circumstances to circumstances depending upon the terms of the contract. Okay, like let's say if the seller A and the buyer B, while making the terms and conditions of the contract of sale, let's say mentioned in the sale agreement that if there is a breach during delivery of the goods in installment, the whole contract will be repudiated, the whole contract will be cancelled. Or let's say if they have fixed the terms and conditions where it has been mentioned that if there is a breach during delivery installment of the goods, only the delivered goods will be accepted. if there is a breach during delivery installment of the goods, only the delivered goods will be accepted by the buyer and the rest will not be accepted. And for the loss faced, the financial loss faced by the buyer for not delivering the rest of the goods by the seller, okay, whether the seller has to compensate or not, whether the seller has to compensate or not, in this regard, these terms and conditions must be expressed. It must be these terms and conditions must be expressly made in the agreement, the sale agreement, while making it, okay, during the formation of the sale agreement, okay. So the fifth point here we can discuss, we will discuss fifth point, the right to examine the goods, right to examine the goods. So where goods are delivered to the buyer, where goods are delivered to the buyer which he had not previously examined, he is not deemed to have accepted them unless and until he has a responsible opportunity of examining them for the purpose of ascertaining whether they are in conformity with the contract. Unless otherwise agreed, when the seller tenders delivery of goods to the buyer, he is bound on request to afford the buyer a reasonable opportunity of examining the goods for the purpose of ascertaining whether they are in conformity with the contract. So, the fifth point, right to examine the goods, right to examine the goods, okay. So, as we were talking about installment deliveries, there is a fourth point. It is getting covered under section 38. Installment deliveries, this is getting covered under section 38 of the Sale of Goods Act 1930. And as far as the fifth point is concerned, that is right to examine the goods, there is a buyer's right of examining the goods. It is getting covered under section 41. Section 41 of the Sale of Goods Act 1930. I am repeating this again. Okay, the fourth point, installment deliveries. It is getting covered under section 38 of the Sale of Goods Act 1930. And the fifth point that we are discussing, right to examine the goods, it is getting covered under section 41 of the Sale of Goods Act 1930, which is talking about buyer's right of examining the goods, okay. So now we are discussing about right to examine the goods, okay, buyer's right to examine the goods. So right to examine the goods, let's say, let me cite one example. Let's say the seller is supposed to deliver B the buyer, let's say, washing machine. Now B the buyer here is having what? He's having B the buyer is having the right to examine that particular product, which is a washing machine here in this example, okay, whether the washing machine, let's say, is having authentic mark or not, or whether it is as per the description given or not. So these things can be examined by the buyer, and the seller is also having the duty to give the buyer what? Reasonable opportunity to examine the product carefully. Now let's say the seller has given to the buyer the reasonable opportunity, but let's say the buyer was reluctant to examine the washing machine. Later on, if in the product it is found having some sort of drawback, okay, some sort of problem, okay, so which the buyer did not want, okay, the seller here cannot be made liable. The seller here cannot be made liable for this. Why? You may ask this question. Because in this example, what happened? The seller, he has given the buyer the reasonable opportunity to examine the washing machine product. Okay, but the buyer was reluctant to examine it. So it will be considered that the buyer has accepted the product here. Okay, but let's say A, the seller, had telephonic conversation with B, the buyer, and B, the buyer, expressed his choice or his desire to buy a particular washing machine, let's say, okay, like for example, Bosch 8 kg fully automatic front load washing machine, okay, having silver color. So A, the seller, next day, without waiting for B, the buyer, to be in his shop for examining the product, let's say send the washing machine to B's house. So here, if the washing machine does not fulfill the requirements of B, the buyer, B can reject the product. Because here in this example, what happened? B did not previously examine the product, because only the buyer B, because only if the buyer B is given the reasonable opportunity to examine the product, then only B will be regarded accepted that particular product. Otherwise, if no reasonable opportunity is given to the buyer, then what will happen? Then the buyer will not be considered as accepted the product. Okay, so now you all may say how you will get reasonable opportunity. If you are buying a product from, let's say, online transaction like Amazon, okay, or other product selling websites. So now through online, you may see the product, examine the product, seeing the pictures of the products, maybe 3D pictures, okay, of the product. But actual examining of the product, it is not possible in this regard. So if an online selling website, it puts a condition that if you purchase the product from that particular website, seeing the pictures of the product, it will be considered that you have been given reasonable opportunity to examine that particular product. Then the transaction will be done. Afterwards, will go as per the conditions regarding the reasonable opportunity. And when the buyer agrees to purchase the product, it will be considered that the buyer accepted this particular condition given in the website. So, but there may be other conditions also which may arise due to agreements which are related to, let's say, warranties, return of the money if the product is not good within a particular period, or there may be other statutory provisions also which can give relief to the buyer, which I think it's a different story altogether. Okay, so unless otherwise agreed, this is very important sentence here, unless otherwise agreed. Okay, unless otherwise agreed, I am reading this again. Buyer is not bound. So we are discussing about this. No, we are discussing the last part of it. Okay, unless otherwise agreed. Unless otherwise agreed, when the seller tenders delivery of goods to the buyer. Unless otherwise agreed, when the seller tenders delivery of goods to the buyer, he is bound on request to afford the buyer a reasonable opportunity of examining the goods for the purpose of ascertaining whether they are in conformity with the contract. I am repeating this again. Unless otherwise agreed, when the seller tenders delivery of goods to the buyer, he is bound on request to afford the buyer a reasonable opportunity of examining the goods for the purpose of ascertaining whether they are in conformity with the contract. Okay, so unless otherwise agreed, this particular sentence here, it is important. So if the contract is something like that, that the reasonable opportunity cannot be given, let's say, to the buyer, and the buyer and the seller through mutual consent agreed to it, then it will be treated as an exception. It will be treated as an exception in this regard. Okay, so let us come to the sixth point here. The sixth point, right of acceptance. Okay, so the buyer is deemed to have accepted the goods, A, when he intimates the seller that he has accepted them, or B, when the goods have been delivered to him and he does any act in relation to them which is inconsistent with the ownership of the seller, or C, when after a reasonable time he retains the goods without intimating to the seller that he has rejected them. So 3 points are there, A, B and C. A, when he intimates the seller that he has accepted them. Let me cite one example. Suppose A and B, they made a contract, and A, the seller, sent B, the buyer, let's say 10 kg of rice, which B, the buyer, needed. Here when B makes an impression in the mind of the seller that he has accepted the good, maybe by making oral or spoken expression, or maybe through affirmative or let's say positive gesture, it will be considered that B the buyer has accepted that particular good. Okay. Point B, when the goods have been delivered to him and he does any act in relation to them, when the goods have been delivered to him and he does any act in relation to them which is inconsistent with the ownership of the seller. So point B here, let me cite one example. Like the seller A, let's say A delivered the good to the buyer B. Now here the ownership has been transferred from whom? From A the seller to B the buyer. Suppose the good was, let's say, 10 kg of rice, and B started cooking the rice after receiving the good, that is 10 kg rice. Only the owner of the rice is having the right to cook from that 10 kg of rice, which means what? It is indicating not only no longer the seller A is not the owner of the 10 kg of rice, but B the buyer also accepted 10 kg of rice, because B the buyer started to cook from it. B the buyer started cooking from it. Okay. So point C now. Point C, when after a reasonable time he retains the goods without intimating to the seller that he has rejected them. Point C. So how to simplify this? Suppose when B the buyer received the good, let's say a frying pan. Okay, the good was a frying pan. Okay, but after receiving, he was not happy with the product, because the frying pan, it had no thick handle, let's say. Okay, so after communicating about the same with the seller, B the buyer decided to return the product to A the seller. So A the seller told that you can return the frying pan anytime and take the money from me. But let's say B did not return the product, the frying pan, and kept the frying pan with him for, let's say, 4 months. So here B will be considered what? That he has become the owner of the frying pan, because here the reasonable time, it got exceeded. If B, let's say, B the buyer, let's say, return the good within 1 week, it could be considered as 1 week time can be easily considered as reasonable time. But 4 months, it is defying our logic, and so it cannot be considered as reasonable time here. Okay, as reasonable time here. Now, buyer is not bound to return rejected goods. Buyer is not bound to return rejected goods unless otherwise agreed. Where goods are delivered to the buyer and he refuses to accept them, having the right so to do. I am repeating this again. Buyer is not bound to return rejected goods unless otherwise agreed. Where goods are delivered to the buyer and he refuses to accept them, having the right so to do. He is not bound to return them to the seller, but it is sufficient if he intimates to the seller that he refuses to accept them. So it is coming under section 43 of the Sale of Goods Act 1930, which is talking about section 43, buyer not bound to return rejected goods. Buyer not bound to return rejected goods. Section 43 of the Sale of Goods Act 1930. How to simplify this? Now suppose B the buyer was not, let's say, satisfied with a particular product, and B decided to return the product to A the seller. Now B here can do this. Suppose B the buyer rejected that particular product. After rejecting the product and communicating about the same to the seller, B may keep the rejected goods. B the buyer may keep the rejected goods with him. Afterwards, A the seller cannot come and say this to B, that since you have rejected the product, you have to return the product. even after rejecting the product and communicating about the same to the seller, the buyer can keep the product. The buyer can keep the product with him, and he is not bound to return the good to the seller. But let's say if there was an agreement, between the buyer and the seller, that immediately after rejecting the good, the buyer has to return the good, and there will be complete return of the money price from the side of the seller also. Then as per the agreement, the seller is bound to return the rejected goods. So we have discussed about what? We have discussed about right of acceptance. Right of acceptance, which is getting covered under section 42. Section 42 of the Sale of Goods Act 1930. Right of acceptance, the sixth point, section 42. Fifth point, right to examine the goods, that is buyer's right of examining the goods. It was getting covered under section 41. And sixth point, that is right of acceptance, it is getting covered under section 42 of the Sale of Goods Act 1930. Okay. Now let us come to right to damages for non-delivery. Right to damages for non-delivery. Let me read it for a while. Where the seller wrongfully neglects or refuses to deliver the goods. Where the seller wrongfully neglects or refuses to deliver the goods to the buyer may sue the seller for damages for non-delivery. So here the measure of damages is the difference between the contract price of the goods and the market price at the time when the goods ought to have been delivered, if there is an available market. Okay. So point number 7, right to damages for non-delivery. So it is getting covered under section 57. Section 57 of the Sale of Goods Act 1930, which is talking about damages for non-delivery. Okay. So let me simplify this. Point number 7, that is right to damages for non-delivery. Suppose the seller did not deliver the good to be the buyer, either maybe due to wrongful neglect, or let's say wrongfully refusing to deliver the good to the buyer. So here the buyer B is having the right to sue the seller. Here the buyer B is having the right to sue the seller. Okay. So the next part of this point number 7 is talking about the measure of damages is the difference between the contract price of the goods and the market price at the time when the goods ought to have been delivered, if there is an available market. To simplify it, let me cite one example here. Now suppose due to non-delivery of the product, let's say the product or the good is a golden necklace, and due to non-delivery, B, the buyer, faced huge loss. As we know, the price of gold depends upon the market and often fluctuates. Okay. So suppose during the time of making contract of sale, the price of the golden necklace, let's say it was 20 lakhs. Okay. And B, the buyer, found it to be a profitable time to purchase the golden necklace. But afterwards, it was found that either seller rejected or refused to deliver the product to be the buyer, and in the meantime the price of that golden necklace it got increased by 2 lakhs. So when the contract was made, the contract price was 20 lakhs, but later on the market price it got increased by 2 lakhs. So the price of the product has now become 22 lakhs. Here B, the buyer, can claim for what? Can claim for compensation from the seller, because B faced loss. He could purchase the golden necklace in a profitable price during the profitable time from other jewelry shop. Okay, but because of contract of sale, uh, he because of contract of sale, he did with the seller, the buyer could not do it, the buyer could not buy. So here the amount of compensation, the amount of compensation to the buyer will be fixed, seeing both the contract price and at the same time seeing the market price. The damages will be here measured by seeing both the contract price and the market price. Okay, the market price. So now the next part of this point number 7, that is we're discussing about right to damages for non-delivery here. So where delivery is delayed, but goods are accepted, where delivery is delayed but goods are accepted, despite the delay, the damages would be the difference between the value of the goods when they ought to have been delivered and the time when they were actually delivered. I am repeating this again. Where delivery is delayed but goods are accepted, despite the delay, the damages would be the difference between the value of the goods which they ought to have been delivered and the time when they were actually delivered. How to simplify this? Let's say B the buyer wanted to purchase 50 baskets of apples from A the seller. A, during the time of selling, claimed that his apples were fresh and that is the reason the price of it was high or more. As his apples were in demand, let's say B the buyer wanted the apples within 2 days, because B had the intention to resell the apples. This intention of B to resell apples, it was well communicated to A the seller. A had the knowledge of it. Okay, but A the seller, what he did is that the seller intentionally and wrongfully delayed the delivery of apples. And as we know, apples are perishable goods. Those green fresh apples turned red or let's say ripened. But despite the delay, B the buyer agreed to accept the goods, that is apples in this example. But as the apples were no longer fresh while reselling those apples, B faced huge loss, let's say. So here the compensation or the damages faced by B the buyer will be measured seeing the price of the good when fixed during the making of the contract, and also seeing the price of the good when it was delivered, making delay. Okay, and also seeing the price of the good when it was really delivered, making delay. So like for example, as those apples were fresh and B the buyer wanted to have fresh apples, 50 baskets within 2 days, let's say the price while making the contract was 30,000 rupees. Now as apples are perishable goods, as we know, and have been delivered after making delay, let's say of 1 week, okay, 1 week delay, the apples lost the freshness. So by applying our common sense, we can understand the loss in the freshness caused the reduction in the price. But the buyer, as accepted the apples, will not return it. But the compensation can be claimed. by the buyer. If during the delay, let's say if during the delay delivery due to loss of freshness of the apples, the price of the apples got reduced by 5,000 rupees, let's say, then accordingly the compensation should be made by the seller. After all, it was the fault of the seller, it was not the fault of the buyer. Okay, so this particular point that we have discussed now, that is point number 7, right to damages for non-delivery, it is getting covered under section 57, damages for non-delivery. Section 57 of the Sale of Goods Act 1930, it is talking about damages for non-delivery. Okay, now let us come to point number 8, right of buyer to specific performance. Right of buyer to specific performance, which is getting covered under section 58. Section 58 of the Sale of Goods Act 1930. It is talking about specific performance. Okay. Point number 8. Right of buyer to specific performance. Section 58 stipulates, subject to the provisions of Chapter 2 of the Specific Relief Act 1877, in any suit for breach of contract to deliver specific or a certain goods, the court may, if it thinks fit, on the application of the plaintiff by its decree, direct that the contract shall be performed specifically, without giving the defendant the option of retaining the goods on payment of damages. The decree may be unconditional or upon such terms and conditions as to damages, payment of the price, or otherwise as the court may deem fit. As the application of the plaintiff may be made at any time before the decree. The remedy is discretionary and will not normally be given if damages are an adequate remedy. Specific performance is granted when and if the goods or articles agreed to be sold have special value or rare qualities. Now, how to simplify this? Point number 8. Right of buyer to specific performance. Right of buyer to specific performance, which is getting covered under section 58. Section 58, it is talking about specific performance. Okay. Now, let's say B the buyer wanted an electronic wheelchair. From the seller A. Now, it was urgent for B the buyer to have this. But even after making the contract of sale, the seller A did not deliver the electronic wheelchair to B the buyer. As such, B the buyer, let's say, faced some sort of physical problems or physical ailments. So B the buyer went to the court and filed a suit against A the seller. So here B has become what? B has become the plaintiff and A has become the defendant. Moreover, B paid the money to A. Let's say B paid the money to A. The court not only may give order to compensate the buyer, but may also order the defendant not to retain the goods or not to retain the good, that is electronic wheelchair in this particular example, not to retain the good anymore and deliver it to B the buyer. So this is the discretion of the court. So here the electronic wheelchair is what? It is having special value, at the same time having rare qualities also. Okay. So this is the example of right of buyer to specific performance. Right of buyer to specific performance, which is getting covered under section 58. Section 58 of the Sale of Goods Act 1930, which is talking about specific performance. Okay. Now, let us come to the next point here, that is point number 9. Point number 9, buyer's remedy in case of breach of warranty. Okay, point number 9, it is talking about buyer's remedy in case of breach of warranty. Now, in the case of breach of warranty by the seller, the buyer may have, there are 3 points here. A, set up against the seller the breach of warranty in diminution or extinction of the price, or B, sue the seller for damages for breach of warranty, or C, in case of further damage arising from the breach of warranty for which diminution or extinction of price has already been claimed, the buyer can also sue for additional damage. Now let me simplify it. Let me simplify this. We are talking about buyer's remedy in case of breach of warranty. Point number 9, buyer's remedy in case of breach of warranty, which is getting covered under section 59. Section 59 of the Sale of Goods Act 1930. It is talking about section 59. It is talking about remedy for breach of warranty. Remedy for breach of warranty. Now, buyer's remedy in case of breach of warranty. Suppose, let me cite one example here to make it more simple. Suppose A the seller and B, the buyer entered into a contract of sale. They entered into a contract of sale. Suppose the product of the good is a let's say refrigerator. Suppose the refrigerator had 2 years warranty, that if within 2 years period defect arises, the refrigerator will be fixed by the company. Suppose after buying the refrigerator by B, the buyer, within 6 months, let's say the refrigerator faced some technical problems, okay, technological problems. Let's say A, the seller, refused to fix the refrigerator. Here B, the buyer, is having three options here. B, the buyer here having three options. Set up against the seller the breach of warranty in diminution or extinction of the price. So either B, the buyer, can claim for the diminution or we can say diminution or reduction in the price of the refrigerator, or can claim for the extinction of the price by demanding the whole amount of the money from the seller. B, sue the seller for damages for breach of warranty. That is, B, the buyer, can file a case against A, the seller, for compensation for the breach of warranty. C, in case of further damage arising from the breach of warranty, for which diminution or extinction of price has already been claimed, the buyer can also sue for additional damage. That is, if due to the damage of the refrigerator, let's say the refrigerator caused short circuit and burned one of the hands of the buyer, then additional compensation can be claimed with the diminution or extinction of the price of the refrigerator here. Okay, so these are some of the simple examples. Okay, now let us come to point number 10. Point number 10, it is talking about what? Repudiation of contract before due date. Repudiation of contract before due date, it is getting covered under section 60. Section 60 of the Sale of Goods Act 1930. Section 60. Let me read it first. So, in the case of repudiation of the contract by the seller before the date of delivery, the buyer may treat the contract as subsisting and wait till the date of delivery, or he may treat the contract as rescinded and sue for damages for the breach. Let me simplify it, okay? Now, as we have discussed this particular point, that is repudiation of contract before due date, it is getting covered under section 60. Repudiation of contract before due date, section 60 of the Sale of Goods Act 1930. Okay? Now let me simplify it. Repudiation of contract before due date. Now here the buyer will have two options. Okay, let's say, let me give two examples here. Let's say in the first example, if the seller was supposed to deliver the good to B, the buyer, let's say within 2 weeks. So there was a contract between A and B. A, the seller, and B, the buyer, but suddenly A, the seller, wrongfully refused to deliver the good. So here, in the first case, B, the buyer, can wait till the 2 weeks time period is finished or over. Or secondly, in the second example, as far as the second example is concerned, B, the buyer, can treat the contract as rescinded and sue A, the seller, for the compensation. Rescinded means what? Cancelled. As far as the second example is concerned, B, the buyer, can do what? B, the buyer, can treat the contract as rescinded and sue A, the seller, for the compensation. Okay. So now point number 11. Right of buyer to interest. Section 61. It is talking about interest by way of damages and special damages. Section 61 of the Sale of Goods Act 1930, it is talking about right of buyer to interest. That is section 61, interest by way of damages and special damages. So point number 11, it is talking about right of buyer to interest. Let me read it. Where the buyer has already paid the price and the seller commits default in delivering the goods, the buyer can claim refund of the price with interest and thereon at such rate as the court thinks fit from the date on which the price was paid. Okay, the price was paid. Now point number 11. Let me make it simple here. Right of buyer to interest. Suppose A the seller. Let's say A the seller was paid by B the buyer. Before the transfer of the good from seller to the buyer, it was made. But afterwards, after getting the payment, the price from B the buyer, A the seller did not deliver the good to B the buyer in the right and the reasonable time. Let's say here it got exceeded the reasonable time. So here B the buyer can claim for damages. Here B the buyer can claim for damages or compensation from A the seller by filing a case in the court of law. And the case can be filed for claiming interest. The case can be filed for claiming interest with the price paid for the good by B the buyer. The court may give order to A the seller to pay interest along with the price of that good to B the buyer. Okay. Now, this is what rights of a buyer it is all about, and in the next lecture I will cover duties of the buyer. Okay, thank you.